President Trump defending his restrictions on travel and immigration, that executive order targeting people from 7 majority Muslim countries where he says terrorism is a concern and should be for Americans. The White House says the order is within the president's powers. Jeffrey Kahn, a constitutional law professor at SMU, has written on that and the issue of terrorism. So the president says it's an issue of national security. And to students of constitutional law, though, there is a precedent that goes back to the Truman days in the Korean War.
There certainly is, Tim. In 1952, President Truman, fearing that a steelworkers' strike was going to prevent the construction of weapons for the Korean War, ordered his Commerce Secretary to seize the steel mills all over the country. He did it the same way with an executive order. It wasn't supposed to be permanent, so there was the same temporal restriction. But right away, the owners of those steel mills went to court, just as the state of Washington and Minnesota and other plaintiffs had, seeking a temporary restraining order, a TRO, in exactly the same way as we see today, saying the president didn't have the power.
And how did that went to the United States Supreme Court rather quickly?
Went very rapidly. In fact, they were seeking the TRO at the door of the home of the chief judge in Washington, D.C. They finally got into court early the next morning. They fought very hard, both sides making what they each thought were compelling arguments, but there was a fundamental difference between each of the two arguments. The arguments for the Justice Department were that the president, because of a national security emergency, had inherent executive authority to keep the country safe. On the other side, the lawyers for the plaintiffs, the steel mills, or in this case, the states and individuals seeking to get their loved ones or refugees access to their own form of security in this country, said the president doesn't have what we'd say today is a blank check to do whatever he thinks is possible. He's got to do what he thinks is best, but within the parameters that Congress has set.
And where did the Supreme Court fall on whether the president can, by emergency executive order, protect the country's national security?
The Supreme Court was willing to be quite deferential to the president, but they weren't willing to go that far. The Supreme Court said that the president cannot just assert a national security emergency and do whatever he thinks is best. He, in conjunction with Congress, sets the policy, and in a very famous concurrence by Justice Jackson explained that sometimes the president's power is at its apex. That's when Congress and the president are working together. Sometimes there's a zone of twilight where we're not really sure what's going on. But equally clear, the president's power is at its lowest ebb, Justice Jackson said, when Congress has set one policy and the president wants to do something else.
The president also attacked the judge, the federal judge in Seattle, a Republican appointee, by the way, and known as a fairly conservative jurist, who ruled against him, referring to him as a so-called judge, again, of course, on Twitter, and the ruling ridiculous. You're, I presume, bothered by that.
I'm deeply, deeply concerned by it. This is, as far as I can tell, never happened before, certainly not with the intensity, frequency, and vitriol that we've seen in the last few weeks, and going back further with the attacks on Judge Curiel during the campaign. The problem is, it's perfectly okay to criticize a judicial opinion. That's why these opinions are written down in the first place. But it is absolutely wrong to attack the person or the individual of the judges themselves. That goes right to the heart of the rule of law, and that is a core foundational value in our country that we shouldn't trifle with.
Do you think this impacts the president's relationship with the judiciary? He's going to be appointing hundreds of federal judges, presumably, over the next 4 years, including naming one to the United States Supreme Court.
Well, we do have a nomination to the Supreme Court, that's true. I think that it's very important that each branch understand that they are co-equal branches in our federal government. And when one branch attacks the integrity or the individual decision makers in their spheres, that's an attack that is very, very dangerous for the country.
Thanks very much, Professor Kahn. We really appreciate it.